Hey everybody, Jonas Callis here of the Hurt at Work Workers' Compensation Law Firm. Many of you know me as the Workers' Comp Guy. First, the obligatory disclaimer. The following information is for informational purposes only and does not constitute legal advice to anyone, nor does it create an attorney-client privilege with anyone. So, still talking about benefits that are available to injured workers in Virginia in the Virginia Workers' Compensation Commission. Today I'll be discussing an important indemnity benefit of a workers' compensation claim, and known as permanent partial disability benefits, or a lot of people shorthanded know it as PPD benefits. In the Virginia Workers' Compensation System, pursuant to Code Section 65.2-503, injured workers, even undocumented workers who are otherwise not eligible for employment in the United States, may be entitled to workers' compensation permanent partial disability benefits for an amputation, partial amputation, loss of use, scarring, or disfigurement of certain body parts that are listed in Section 65.2-503. These permanent partial disability benefits are intended to compensate the injured workers for such permanent partial loss of use, the loss of functionality of those certain body parts, or for kind of an unsavory disfigurement, a lifetime's worth of unsavory disfigurement of that body part, and that last part goes more towards the scarring and disfigurement. To be clear, permanent partial disability benefits are paid to injured workers whose industrial injuries result in permanent impairment and disability, even though the injured workers are able to return to work in some capacity. You don't have to be permanently and completely disabled, in other words, to collect permanent partial disability benefits in Virginia. So, when can an injured worker get permanent partial disability benefits? To receive PPD benefits, the injured worker must first timely file a claim for benefits requesting permanent partial disability benefits, and then should it not be just outright accepted by the employer and/or its workers' compensation insurance company, the injured worker would have to submit admissible medical evidence in support of his or her claim, and not just medical evidence, possibly other evidence as well. So what kind of evidence is typically the evidence that we put on for permanent partial disability claims? It's largely medical, but sometimes injured workers will testify as to the injuries they sustained in their workplace accident or from their workplace disease and how it continues to affect them, basically. So, but before, in terms of the medical evidence, before an injured worker can collect permanent partial disability benefits, the injured worker must have been declared to have reached maximum medical improvement for each for the body part at issue. Okay, typically, maximum medical improvement is also referred to as MMI. Typically, MMI is established by credible medical opinions to a reasonable degree of medical certainty by healthcare professionals, largely doctors and physician's assistants. So that's the first thing. The injured worker has to have reached MMI, okay? In addition to reaching MMI, the injured worker has to have a healthcare professional that offers an opinion stating that the injured worker has some sort of functional loss of capacity or loss of use to said body part, and that that loss of functionality is typically rated, some sort of percentage loss. Okay, it's This aspect of the permanent partial disability claim is proven through medical evidence as usual, typically a disability rating that assigns some sort of level of percentage impairment to the body part, to an arm, to a leg, something like to a finger, something like that. And usually it explains the rationale behind that finding, okay? Typically a physical therapist or a physiatrist or somebody who normally does functional capacity evaluations will, with an eye towards an impairment rating of a body part, will actually examine the injured worker, have him or her go through some testing to kind of make that determination, okay? And in the end, in their report, they will offer a percentage permanent impairment rating, partial permanent impairment rating to a body part or multiple body parts. Now, this is worth something, but it's typically not worth as much as the treating physician or treating physicians signing off on that recommended percentage impairment by the physical therapist or the physiatrist or somebody, right? Once the treating physician or physicians sign off on or approve that recommended partial loss of functionality, then it's pretty good medical evidence that the commission will listen to more readily, I guess is a good way to put it. Usually, these determinations are made using the AMA guidelines or guides to the evaluation of permanent impairment, okay? That goes a long way with the commission. And a good way to put it is if one doctor doesn't use the AMA guides or uses it but doesn't reference it or doesn't explain that he or she did use it, and another doctor did use it and says that pursuant to the AMA guides to the evaluation of permanent impairment, that the rating, the opinion that uses it will be often afforded more weight by the Virginia Workers' Compensation Commission. So that's the second. Those are the two medical aspects, okay? The injured worker has to have reached MMI, and somebody, preferably a treating physician, has to have opined that the injured worker has suffered some sort of permanent partial loss of use. 20% permanent partial loss of use to the right arm, or the left leg, or something like that. Okay. Now, the third piece of evidence, which sometimes comes into play, because truth be told, PPD benefits can sometimes be a nice chunk of money. Depends on the compensation rate and the percentage loss of use, i.e. the severity of the injury to the body part. So a lot of times, insurance companies will contest the claim for PPD benefits. The insurance companies will have their own stable of doctors that they will use and go back to time and again to get opinions which tend to be on the low side. So where the treating physician may say, yes, I think the injured worker has a 30% permanent partial loss of use to the right arm. One of the insurance company's doctors might say, nah, that's too high. It's only an 8%, right? So that's kind of how that works. So what additional evidence that can sometimes help the commission determine what the actual permanent partial loss of use is actual testimony from the injured worker. The injured worker can testify if it's really a significant injury to the right arm. Maybe the injured worker testifies, yeah, I used to lift weights regularly. I used to bench press 335 pounds. And since the accident, I've only been able to get up to 150 pounds before my arm starts hurting me again. I just can't do much with it anymore. I mean, that's pretty good, but it's not nearly where I was before, right? That kind of stuff, whatever. I don't know. I used to play basketball. I can't play basketball anymore. I have to shoot with my left hand. I don't know. Something like that, right? So things like that can go a long way towards helping the commission decide. And when they're faced with two medical opinions from two licensed healthcare professionals that kind of vary widely, right? So, a note about maximum medical improvement. Maybe the first time some of you have heard that term. MMI is a determination reserved for licensed healthcare professionals. Okay, it's not something, and usually using that AMA guide that we talked about. So it's not something that the injured worker, typically a lay person, a layperson in terms of medical opinions, will not be able to offer an opinion about that's worth anything. Okay. What does it mean exactly? Injured workers typically declare to have reached MMI only when there is no reasonable expectation that he or she will obtain functional improvement in her or his body part, even with ongoing future medical treatment. Okay, so they've maxed out. I mean, it's kind of in the name, right? Maximum medical improvement. You've maxed out how much that body part will improve. With a reasonable degree of medical certainty, such and such doctor believes that it's not going to improve anymore, right? So that would be MMI. Now, what does that mean? Like, the injury can still remain symptomatic, right, and disabling to some point, right? It just means that the injury is not supposed to improve anymore. A lot of times I've seen workers' compensation insurance claims adjusters, and also employers say that, well, they've reached MMI, they're done, they're back to their baseline level. They're 100%. That's not what that means. It does not mean that the injury or injuries have totally healed, and that the injured worker is back to her or his pre-accident level and functioning level, and so that causes problems sometimes. MMI does not mean you don't need any future treatment. It might mean that it might happen to coincide with the doctor's opinion that you don't need any future treatment, you've reached maximum medical improvement, et cetera, but it might mean this is as good as it's going to get. You're going to need treatment for at least the next 10, 15 years. So there are a lot of other factors that go into that, but that's all that MMI means. Another point I wanted to make about MMI. There's no set time limit for MMI, right? Some people heal quicker than others. Quite frankly, I hate to say this, but some doctors and therapy centers and stuff are better than others, right? Some accidents are worse than others. People vary, accidents vary. Injuries vary. Some people may reach MMI in 3 months or 6 months, right? Depending on the injury and how young they are, how quickly they heal. And other people could take years, decades, depending on the severity of the injury. Catastrophic injuries may not ever reach it. I mean, they may reach MMI at a certain point, but they'll continue to require treatment, ongoing treatment. So again, it really doesn't matter when anyone but the treating, or often the treating doctors, what the doctors that are familiar with the claim, what they think about it. I think that's all I wanted to say about MMI specifically as an aside. If after examining the medical evidence largely, and to some extent, like we talked about, the injured worker's testimony or any other testimony that may be relevant, the commission determines that the worker's in MMI and has suffered some sort of impairment, they will award PPD benefits. That's how that works. So for how long can an injured worker get paid PPD benefits? That's an interesting question. If you've reviewed my website and seen my videos on temporary total disability benefits and temporary partial disability benefits, those benefits are more of a weekly check type of benefits, okay? PPD benefits is not quite the same way. A lot of times it comes in a lump sum check payment that covers X number of weeks, right? But it's really often in the form of one check payment for that lump sum. But I think the better way to look at it is, pursuant to Section 65.2-518, injured workers can receive temporary total disability benefits, temporary partial disability benefits, and or permanent partial disability benefits, or some combination of those three for up to 500 weeks. Okay, so even though many injured, like we've talked about, and even though many injured workers suffer injuries that may be at least somewhat permanent in nature and somewhat permanently disabling, they just can't, according to the law, they cannot receive those three types of benefits, TTD, TPD, PPD, for over 500 weeks. So this is somewhat contrary to what the name suggests, right? So in fact, permanent partial disability benefits does not mean permanent at all, right? Because in conjunction with the other two types of temporary benefits, are limited, capped at 500 weeks. How much? This is the most important question, I think. This is the question I often get. How much can I get in PPD benefits, right? The way the Virginia Workers' Compensation Commission calculates it, it's calculated pursuant to a schedule or a list, or however you want to think about it, a scheduled loss approach to determine, I guess, whether the employee is entitled, as an initial matter, to PPD benefits for a certain body part, because not all body parts are covered. And if so, the extent of permanent disability and the amount of PPD benefits to actually be paid, okay? Under this scheduled loss approach, the Workers' Compensation Act provides us, like I said, a schedule or list of body parts that are covered and allowed to be awarded PPD benefits for. If an injured worker suffers an injury that ends up being permanent to a body part that's on that list in section 65.2-503, then the injured employee is entitled to permanent partial disability benefits for that body part based on the number of weeks for each injured body part. And those weeks will vary if you look at section 65.2-503, which is where the list or the schedule is. Typically, how it's calculated specifically, the PPD benefits are determined by multiplying the doctor-assessed impairment percentage, okay? Let's say 20% or 30% permanent partial loss of use of the right arm, or something like that, okay? To times the number of weeks listed in section 65.2-503, okay? So for example, an arm is worth, like if it's 100% loss of use to the arm, it's 200 weeks. So 30% loss of use to like a right arm or a left arm would be 60 weeks. So you would take that 60 weeks and multiply it times the percentage, the partial permanent loss of use that we just talked about. I think I said 30%. So 30% times the 60 weeks, right? And then you would take that number and multiply it by the injured worker's non-cost of living adjusted compensation rate, right? Which is basically, if you saw some of my other videos or reviewed my website, it would be the pre-accident average weekly wage, 2/3 of that, right? That would be your comp rate, okay? So that's how that works. So for example, an employee who earns $1,200 per week gross, okay, hurts her left shoulder on the job. She reaches maximum medical improvement, I can't speak. And her treating physician sends her to an examiner who states that she has a 30% permanent impairment rating, permanent partial impairment rating to the left arm because of the work-related accident. The treating doctor, who's familiar with her care, signs off on that and says, yeah, I agree, 30% sounds about right. That's why I would have ballparked it. Okay, so the injured worker's pre-accident average weekly wage is $1,200, right? So 2/3 of that, right, is $800, right? So her compensation rate is $800. Pursuant to the schedule found in 65.2-503, the left arm, the number of weeks provided for an arm injury, like I said, is 200 weeks. So you would take in total, she would be entitled to $48,000, okay? Well, how do we get there? All right. You take the 30%, right, for the 30% permanent partial loss of use, multiply it by the 200 weeks for the left arm, for an arm injury, right? And then you multiply that times the $800 comp rate, right? And that gets you to $48,000. So that would be the PPD benefits she would be entitled to. So you have a pretty high comp rate and pre-accident average weekly wage. You have I think that's a pretty significant injury, a 30% injury to your arm. I mean, it's not 5 or 10, right? So, as you can see, PPD benefits can add up, right? So that's an important chunk of change. I don't think anybody would pass on $48,000 in that example. And just to kind of retouch on this, so you see that an injured worker, normal, even though it says permanent, sometimes the language that's used can be confusing. But even though it says permanent partial disability benefits, right? Disability and permanent, like you don't have to have a loss of the whole arm to get PPD benefits. You can have some percentage loss and still get PPD benefits. That's important because I know some injured workers think the opposite, okay? Side note, as discussed elsewhere on my website and in my videos, the Virginia Workers' Compensation Commission does not have any provision for pain and suffering benefits, okay? So obviously, even though injured workers do go through some pain and suffering with work-related accidents, they cannot collect a monetary award specifically for pain and suffering. Now, that said, where in accidents where employees suffer more significant types of injuries, the severely injured body part can cause pain, numbness, tingling, whatever, which may radiate into other areas and cause other problems, right? For example, a severe neck injury might cause kind of radiation, pain, and tingling and numbness down both arms. You can have radiculopathy down both arms, right? Well, arms are rateable. A neck may not be covered, but arms are rateable pursuant to 65.2-503, right? Same thing with like a back injury. Back injuries themselves are not covered under the PPD statute, okay? But sometimes when you have a lumbar injury, you can have pinched nerve, which can cause sciatica, similar type of radiation, numbness, tingling down a leg or both legs, right? So you can, if you are suffering that, you can collect PPD benefits pursuant to 65.2-503 for your legs, even for a back injury. Another ninja tip. Here's a ninja tip that I wanted to say about the PPD benefits. Obviously, like we've talked about, PPD benefits are based, at least in part, on the injured workers' comp rate, which that comes from the pre-accident average weekly wage, okay? So it's very important to get the pre-accident average weekly wage correct. So injured workers, so in addition to just the weekly checks, everybody understands that, right? Your gross earnings from your weekly checks for the 52 weeks leading up to the accident. Everybody gets that, right? But what's also included in that are like job perks that you can kind of monetize and quantify. Those perks should be rolled into your regular paycheck to determine your actual pre-accident average weekly wage. I get it. Most people don't have perks that are quantifiable, but some people do, and to the extent you do, they should be folded in. In addition, some workers work similar employment, right? So a good example of this is like a housekeeper, right? If you have a housekeeper that works for company A and also works for company B, but she was hurt on the job at company A, right? Well, to the extent the company B job is also a housekeeper job, did the same thing, went around to the rooms, cleaned the rooms, changed the bed sheets, cleaned the bathroom, vacuumed the floor, et cetera, did the same job basically, or similar job, right? You can actually combine those two for your average weekly wage, right? So you would also need to look at the wages that you earned from the second similar employment, as well as any perks that you had that are quantifiable in that employment as well. So that's important because, as you can see from that last example of our PPD benefits, that as your comp rate is a significant part of that, right? And a higher pre-accident average weekly wage will allow you to get more workers' compensation benefits for your claim, for your injuries. Okay, so next I wanted to mention that if you look up 65.2-503, you'll notice that it does not provide for permanent partial disability benefits for back injuries, neck injuries, kidney injuries, brain injuries, or loss of teeth. In fact, no provision in Virginia Workers' Compensation Act provides for that, okay? Now, we kind of touched on this. To the extent that one of these excluded body parts causes injury or damage, symptoms, whatever, to other body parts, you can receive the PPD benefits for those other body parts. So it's not a complete bar, okay? You can't receive PPD benefits for just a back injury, though, okay? Or just a spinal injury or any of the other body parts, loss of teeth, that are included in that segment. So last thing, I wanted to mention that injured workers may be entitled to PPD benefits for scarring and disfigurement. I don't have a lot to say about this. It's pretty obvious, I think. you could have had a pretty gruesome injury maybe that actually healed well, but you still have kind of a nasty looking scar, even without any permanent partial functional loss of use. You could be like sailing along, but just with kind of a nasty looking scar. You can actually get PPD benefits for the nasty looking scar. And that would involve what's called a viewing. You would have a viewing before the deputy commissioner, who would kind of make a judgment call on that. But it's just important to know that scars and disfigurement also entitle you to permanent partial disability benefits. I think I think I hit the main points today on PPD benefits. So I think that's all I wanted to say today about that, about permanent partial disability in the Virginia Workers' Compensation Commission. I hope the video was helpful. Thank you for watching it. Should you want more information, check out my website. First of all, check out my other YouTube videos and any blog posts. The website is www.hurtatworkinva.com. That's www.hurtatworkinva.com. Also, follow us on Facebook, YouTube, Twitter, because we post other information on those sites as well. The information is geared towards non-attorney people who might get hurt at work, okay? It's for informational purposes. I'm trying to spread the wealth here and let people know so they don't get kind of cheated out of benefits by the employers and especially the workers' compensation insurance companies. And so if you have found this information, this video, or my other videos, or my website, if you found any of that helpful, chances are someone else would find it helpful too. So tell your friends, tell your family members. They may know someone that's going through this, even though you may not know that someone, right? So tell everybody, get the word out there that this website and these videos provide useful information for people to maybe get a little bit more benefits from out of their workers' compensation claim. Certainly they deserve it, because being injured unexpectedly is tough. So I think that's all I have for now. Stay safe, and until next time, don't get hurt at work.